Now calling 20F55085. This is the people of the state of Michigan versus Larry Michael Matthews Jr., also known as Larry Matthews Bay. Police agency report number 2090732. Attorney Reiser, your appearance.
Patricia Reiser on behalf of the people.
Okay, thank you. So this is a complaint for felony non-support. It charges that on or about or between the dates of December 1st, 2010 through September 30th of 2013, you did not pay support for your child in the amount or at the time stated in an order entered by the Washtenaw County Circuit Court in file number 1996-005563-DP. This is a felony with a maximum potential penalty of up to 4 years in jail, a $2,000 fine plus court costs, or both. Do you understand all of that?
No, I have a question. Is this a criminal case or a civil case?
It's being charged as felony non-support, criminal case.
So, who is the injured party?
Okay, sir, when I ask if you understand what you're being charged with, I'm not asking if you agree with it or even if you understand why. I'm asking if you comprehend the words coming out of my mouth. So.
Because for it to be criminal, then it needs to be an injured party, and I need to speak and see the injured party in the criminal case.
And this is an arraignment where I am telling you what you're being charged with.
Okay.
If you do not comprehend the charge against you, then you can go to the door and tell the jail that you're finished, and they can try arraigning you again tomorrow. As I stated, I'm not asking if you agree with the charge or even if you understand why you're being charged with it. What we are doing today is telling you what you are being charged with and what the potential penalty is.
All right.
Okay, so you are being charged with failing to pay child support.
Okay.
Is that something that you understand? Or comprehend? And do you also comprehend the potential penalty here being up to 4 years in jail, a $2,000 fine plus court costs, or both?
I do. I comprehend what is the punishment for that crime.
Thank you, sir. So, as I stated, this is a felony. You do have the right to remain silent. Anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. To a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings. That is before, during, and after trial. If you cannot afford an attorney, one can be appointed for you, although my understanding is that you have refused the services of the public defender today. So, you are not required to disclose citizenship status to the court. You do have the right to consult with an attorney to see if this case would have any effect on your citizenship status. If that part doesn't apply to you, don't worry about it. Do you have any questions about your rights?
Questions?
Okay, thank you. So because, as I stated, this is a felony, you have the right in this case to a preliminary examination that must be scheduled within the next 21 days. For a judge, where the prosecution must present sufficient testimony and evidence to establish that probable cause exists to believe that a crime has been committed, and that probable cause exists to believe that you committed the crime. So that is a hearing to determine whether or not the case is strong enough to go to trial. If the court determines that the case is strong enough, then it will be bound over. That is transferred to the circuit court, which is where your actual trial will take place. Okay. Prior to the preliminary examination, the court will schedule a probable cause conference. That is a hearing and an opportunity for your attorney to meet with the prosecution to discuss your case for any potential issues or resolutions. Your probable cause conference will be March 26th, 2026. That will be at 9 in the morning, in person at the 14A1 District Court in Courtroom C. 14A1 is the courthouse that's located basically above where you are right now at the jail.
Okay, can I grab a pen so I can write this down?
You're going to get paperwork.
Okay.
Okay. So, the court is going to set bond. Bond is set in all cases. The purpose is two things. One is to ensure your appearance at future court dates. The other is for the protection of the public. I will note that this being a felony, failing to pay child support case, that there is a statutorily required bond that is 25% of the amount that is claimed to be owing. And give me just a second because I'm looking up what that amount is because the copy that I have here is illegible. So, Attorney Reiser, did you want to address bond?
Your Honor, I typically in these cases ask for an amount equivalent to the amount that is outstanding or substantially close to the amount. I am trying to read what that is. Also, it looks like $67,218.49.
Yes, I was hoping that there would be something in JIS about it, and there is not.
So given that high amount, I would ask for $50,000.
The warrant that was placed, may I have a copy of that signed warrant also? Because from my understanding, that warrant was placed in 2020, and I went to court in 2021 in Murfreesboro, Tennessee, in Rutherford County Court. I was subpoenaed to go to court.
Okay.
Because I live in Tennessee. I did appear to that court hearing, and a judge ruled in that hearing and sent paperwork to you. I sent paperwork, certified mail, to ensure that you received it, and I was not aware of any warrants for my arrest.
All right. So let me clarify this. One, I was not a magistrate in 2020, so I have none of the paperwork to which you are referring. The child support case would be up at the circuit court, so I do not have a copy of that regardless. And being that this is a weekend arraignment, the only thing that I have in front of me right now is the felony warrant and some other related documentation to that. So I have none of the paperwork that you're talking about.
The felony warrant was signed and dated when?
August 14th of 2020.
Right. So, at this point, I've been dragged away from my family, my 13-year-old son, my business. My son, Uriel Miller, was killed January 12th of 2025. And this month, the trial for his murderer is starting, and I'm stuck here in jail. My wife is going to have to go into that courtroom to face the killer of our son by herself. I am not a flight risk. I went to that court date on September 9th of 2021. That docket number was 21C as in cat, V as in Victor, 820.
So, sir, my condolences for your loss. There's not really anything that I can say about other than to offer my condolences there. What I will say is that as magistrate doing a weekend arraignment, I am statutorily required at this point to set the minimum 25% bond on the felony non-support matter. So I am setting your bond in the amount of $18,000 cash or surety.
Okay.
Okay. Your next court date, as I said, is going to be March 26th. And you are free to consult with an attorney between now and that court date. But your hearing this morning is concluded. You are free to go to the door and tell the jail that you are finished.
Okay, I have one more question.
Yes.
Concerning receiving documents and paperwork while I'm in this jail, what is the process for that?
You're going to have to talk to the people who work in the jail.
Okay.
Okay. Thank you.